Okay, it's 9:02. I think I'm going to start this off. I'd like to say good morning to everyone. Thank you for joining us today. My name is Celeste Walsh, and I'm with the Erie Institute of Law, an affiliate of the Bar Association of Erie County. We have a couple of housekeeping items before we get started. We'd like to use virtual best practices that will help all of us enjoy today's program. All attendees have been muted. Our presenter will take questions via the chat box. The chat box is located at the bottom of your screen, as most of you that have used Zoom probably know. But if you don't, please take a moment to find it. Make sure that your chat is directed at everyone so all can see your questions. Attendance will be monitored today using the CLE form you received in the confirmation email I sent you. The CLE and the evaluation form are both fillable forms. Please complete both of those forms and return them to me at the end of the conclusion of this program. My email address is cwalsh@eriebar.org. That's C as in Charlie, Walsh, WALSH @eriebar.org. I'll put my email address in the chat box for everyone to see. At this time, I'm pleased to introduce Megan Corcoran, President of the UB Alumni Gold Group. All yours, Megan.
Thanks, Celeste. Thanks everybody for attending. We just wanted to say a quick thank you to our sponsors as well. AXA Advisors, Chicago Title, Council Press, Fine Law, Jack W. Hunt and Associates, Precisions Resolution, and Paramount Settling Planning. Thanks again. And also thank you to our sponsor, Stephen Pieper. He is a member and vice president from Hurwitz and Fine. Steve focuses his practice in insurance coverage analysis and coverage litigation for both first and third party claims. He is co-chair of the firm's insurance coverage practice group and head of the firm's first party team. And he also authors a bi-weekly column entitled Pieper on Property that focuses on recent developments in first party coverage disputes. And he is a graduate from the University of Buffalo Law School. So thank you, Steve, and I'll hand it over to you.
Thanks, Meg. I am a graduate, although sadly I'm outside of my gold years. I've moved on to maybe platinum years, although not too far outside of the gold years. In any event, thank you for all of you who joined today. The point of this, as we all know, because everyone I assume is logged in from home, is that this whole coronavirus COVID-19 thing is kind of a big deal. And if you've been paying attention at all to the business side of this, which I imagine most of you have, the insurance issues that go along with COVID-19 and what has basically been the fundamental shutdown of our economy are hot. They're being openly debated in all 50 legislatures around the country right now. And they are a big deal in Washington as well, right? So this purpose is to give you some idea of what we've seen before, of what I don't think is covered, and what possibly could be covered, and where we're kind of going. It's not meant to be a crystal ball to tell you what's going to happen, because I don't think myself or anybody else would be able to tell you that. Is frankly, people are still writing the laws. But despite what you've heard, business interruption insurance has been around, has been litigated, and people actually handled business interruption coverage cases before March 2020. I will tell you this as well. After March 2020, we went from a very, very small group of people who handled business interruption to a very, very large group of people who handled business interruption. So there's a lot of people out there who are becoming experts daily on this, and we expect that would continue. So again, we're going to walk through what business interruption insurance is, what it's meant to cover traditionally, historically, some of the case law that's been developed as a result of litigation over the last 25, 30 years in New York and how it impacts New Yorkers and New York businesses. And then I'll look at some of the legislative initiatives at the end of what's going on in Albany and as well as nationally. If you have any questions throughout this, though, please, by all means, post your questions. Someone, I'm told, I think Meg actually, will get them to me and we'll answer them as we go as best I can. With, again, this proviso that I do not have a crystal ball. So your mileage may vary on some of the answers I give you. In any event, if I can move my slide, there we go. So the basic things that you should remember, and this doesn't matter, this is the same as if we're talking about basic property insurance, if we're talking about automobile insurance, if we're talking about commercial general liability insurance, it doesn't matter what kind of insurance you're talking about. If you are a lawyer, or if you are someone who is reading a policy, even if you're not a lawyer, the way you analyze coverage doesn't change. And the beauty of that is that means you can read a policy and you can read it consistently. You should be able to figure it out, at least get to a reasonable explanation at the end of the process. So every case comes in, every issue comes in, every claim comes in with a phone call. That's normally how it goes, right? And so the things to remember at the outset of any coverage investigation, and it doesn't matter if you are taking a phone call from a business who's asking questions about whether or not they're entitled to coverage under their policy for being shut down as a result of COVID-19, or if you're working for an insurance company and they're calling to ask, do we have to cover this? And what are our obligations under the policy? Doesn't matter. The investigation is the same. What kind of case do I have? Who's my client? What do they do? What kind of documents do I have? What do I have? What have they given me to support whatever their position is, or what they want me to look at? And then probably most importantly, what do I need moving forward to complete this investigation, to complete this assessment analysis? First thing you should do in any case, frankly, and definitely in an insurance case, is look at who's involved. Who are the cast of characters? Who's involved? What are the elements necessary as a valid claim? Who knew what and when? And what do I need again going forward? You know, we have this conversation constantly with associates at the office. If you're going into a deposition, if you're going into a case, if you're going into a coverage analysis, it doesn't matter what it is. If you can't answer these 4 points, then you should go back and do some more preparation, because these are the things that ultimately will drive the conclusion you reach at the end of an analysis, right? So that's the point here. Establish your cast of characters, figure out what you need and who you need it from, and how you're going to go get it. No different in an insurance context as it would be in any other walk of life, frankly. So now that you've got all your information, primarily the one thing that you really need in an insurance case, the one thing that you cannot avoid getting and looking at, is the policy. That's the contract which drives the arrangement, drives the duties of the insurance company, and drives the obligations of the policyholder. You need the policy. When you get the policy, you need to read the entire policy, particularly with business interruption coverage. And here's why. Business interruption coverage is built basically typically out of 3 main coverage endorsements in a policy, right? So if you're a business and you have a commercial property policy, typically you have 3 endorsements. The first endorsement is the main coverage grant, which provides coverage for your building, the stuff inside the building, the trees and shrubbery on the outside of the building, your personal property in the building, the fixtures in the building. It's the equivalent of your homeowner's coverage, right? Think of it that way. If you've never seen a business policy, if you have a homeowner's coverage, you have a renter's policy, it's basically the same idea. The property policy covers exactly what you would think, covers property. In addition to that main endorsement, there's a second endorsement. The second endorsement, generally in a commercial property policy, has the exclusions and the limitations and otherwise the restrictions of coverage, which really define the overall scope of what the insurance company agrees to pay for your loss. Business interruption, that coverage is found normally in a third endorsement. And the third endorsement is written specifically for, excuse me, written specifically for business interruption coverage. But that endorsement alone has additional grants of coverage in it including extra expense, civil authority, and there's some other coverage extensions that we'll walk through. So what does this mean? It means that you have to start at the beginning of the policy and you have to read all the way through, because the language in one endorsement, particularly in a business interruption claim, is oftentimes impacted by language in other endorsements. They're also, in addition to these main three, you want to read to the end of the policy, because what happens in property insurance, maybe more than any other kind of insurance, what happens is you've got a very, very broad grant of coverage, which says basically we cover everything. And there are exclusions which limit it back. And then insurance companies will grant very specific areas of coverage. They'll grant extensions back into the policy. So it's in initially, then it's excluded out, and then it's brought back in as a sublimit or some other addition to the policy. So you have to read the entirety of the policy from letter one in the first page, first column, all the way to the last letter in the last page, last column, and everywhere in between. What is business income coverage, right? The basic goal is to preserve the continuity of the insured's earnings, cover losses arising from an inability to continue normal business operations as a result of damage sustained or a hazard insured against. Keep that in mind. Business interruption insurance almost invariably is tied back to what does the actual property policy cover. If you don't have coverage under the property policy, it's very difficult, not impossible because all policies are written a little differently, but under the normal policy, it's very difficult to trigger business interruption coverage. So you'll see they're tied together. You've got to be able to establish, listen, I had a loss. It's covered under this portion of the policy, the main coverage grant for property damage. And as a result of that property damage, which is covered, I also have a business interruption loss, which is also covered under this policy. That's the typical analysis. There's no double recovery meant in business income. What does that mean? It means that you get the net, not the gross. Business losses must be reduced by profits earned and other insurance payments recovered during the loss period as well. There's a really interesting issue that's coming. We deal with it later in the PowerPoint, but there's a lot of federal funding out there, and the question is how that will impact this basic concept of an insured doesn't get a windfall by an insurance claim. So again, if you're doing policy analysis, someone who's worked with Dan Cohen for 15 years now, you have to put this in every PowerPoint. I'm putting it in this one. One of these days I'll take credit for this, but when he's not looking, and he probably is. In any event, coverage equals what's in minus what's out plus compliance with policy conditions. What the heck does that mean? What's in basically, again, is the grant of coverage. What is the policy telling you we're going to cover? What's out of the exclusions? What is the policy telling you we're taking out of that grant of coverage? And then compliance with policy conditions, again, are the duties that an insured owes as part of putting in a claim. So what are those? The duty to submit documentation to support the claim, the obligation of the insured to show up at an examination under oath and to permit the insurance company to investigate the claim, the obligation to provide notice, the obligation to mitigate damages. Those are the types of conditions that you'll see in a first party case and you'll see in a business interruption case. The basic grant of coverage in a business interruption claim. We will pay, that would be the carrier, the actual business income you sustained during the necessary suspension of your operations during the period of restoration. The suspension must be caused by a direct physical loss of or damage to property at premises which is described in the declarations and for which a business income limit of insurance is shown in the declarations. Cause of loss must be caused by a covered cause of loss. So let's unpack this a little bit because this is the grant of coverage for a business interruption. Again, almost invariably, this is the typical thing that you'll see, right? There's a bunch of things that you have to trigger. The first thing you have to show is actual loss. Not, I would have had this not happened, but actual loss as a result of an interruption to your business. You can prove actual loss by saying, this is what we've done historically, and as a result, this is what we would have done but you have to have some basis in fact and some basis in experience to establish actual loss. Can't be made up. You sustain as a result of the necessary suspension. So you have to suspend operations. That term is in quotation, so that tells you it's defined in a policy, and it almost always is. So you have to have loss as a result of not being able to operate. Operations are also defined. During the period of restoration, which is also defined. Risk of loss as a result of not being able to go to work during a specific time period under the policy. The suspension has to be caused by direct physical loss or damage to property. That's the section which ties it back to the main coverage grant of your property policy covering your building and the stuff inside of it, right? Must be caused by direct physical loss of or damage to property and must be caused by a covered cause of loss. Covered cause of loss is a concept that is applied in the property coverage, not in the business interruption coverage. And what a covered cause of loss generally is in a policy is a risk of direct physical loss not otherwise excluded or limited by the terms and conditions of this policy. So what the heck does that actually mean? What it means is everything is covered under a property policy, under an all-risk property policy, unless it's excluded or otherwise limited by that second endorsement that I mentioned earlier. First endorsement puts everything in, second endorsement takes some stuff out. You have to have a covered cause of loss, a covered damage, covered physical loss or damage to property to trigger business interruption under a typical policy. There are other policies which have tweaked this language over the years. That's why you have to read them. So they may not have a requirement of direct physical loss. They may not require it to be a covered cause of loss. But the typical Insurance Services Office's policy, which you'll see, has this language and includes it. Four fundamental elements, again, we'll hammer this home, has to be caused by an actual interruption of operations during the policy period. The interruption has to be caused by direct physical loss or damage, and the physical loss must be caused by, again, something that's covered under the actual the property damage policy at issue. And it must occur at the insured property for the basic coverage grant. You have to have damage at your property, which is covered by your policy, to trigger business interruption coverage. What's in? Was the policy in effect on the date of loss? These are the questions you have to answer. Is it a covered cause of loss, i.e., is it otherwise excluded? What the cause of why you were closed, is it excluded? Is there evidence of direct physical damage, period of restoration, suspension of operations? And are there any coverage extensions that might apply? Extra expense civil authority are issues that are a little beyond the typical coverage grant that we just walked through. So what is a covered cause of loss? Again, we walked through it. It's a risk of direct physical loss, but the Grancelli case, which is at the bottom of the PowerPoint, probably, it may be the only case in New York State that I am aware of which equates direct physical loss in a business interruption claim to proximate cause. So you have to look at, is there approximate causation between what damage or loss you sustained and the ultimate loss of income? If you can establish that causal link, you've established that you've got a covered cause of loss and you met one of the requirements to establish a business interruption claim. Has there been physical damage? There's a couple examples to walk through. A great example of this, which really brings us home, is, and you'll notice if you ever do any research on this, that a lot of New York law on business interruption was driven after 9/11. There's substantial litigation, so you'll see most of the sites will be from 2004 to about 2009. It's 9/11 litigation because you need to trigger big business interruption losses. You need actions that are beyond singular losses. So what happened? Obviously, we remember 9/11. Some of us do. All of us know about it, I trust. What happened after 9/11 was the FAA shut down all air traffic. And so the Philadelphia Parking Authority, who's not even New York, but the policy was written under New York law and it was litigated in New York, made a claim for business interruption because no one went to the airport. No one went to the airport because no one could get on a plane and go anywhere. So the parking lot lost revenue, doubtless lost revenue because no one could go there. And what happened is the court said, yes, Philadelphia parking lot, you did lose revenue, but you did not have a covered cause of loss at the insured location. You don't have a claim for damage under your first under your first part of that policy. You don't have a claim for damage. So as a result, you don't have a business interruption claim. A collapsed building which is adjacent to the insured location does not constitute physical damage. What happened at Roundabout Theater is the building fell down next to them after 9/11. And the argument was, well, no one could come to our playhouse as a result of the building next to us had collapsed and the street was shut down. It was difficult to get there. Again, you didn't have physical damage. So therefore, you don't have a claim under that first part of the policy, your property policy. You don't have a bodily injury claim. There are a number of these. We'll walk through them quickly to keep this moving, where the loss of the building renders the insured location inoperable. Coverage may attach, but you've got location, it's at least location centric. So you've got a building that has multiple floors, you have damage on one, you may be able to make a claim that you've got damage beyond that. Loss of electronically stored data is not considered physical damage. The Lava Trading case, again, it comes right out of the World Trade Center. If your office space is damaged and you cannot access it, you cannot use it, clearly that qualifies as physical damage. Next part of this analysis. So let's say you've got physical damage. And you may, that's an issue that will be, I will bet you all that's an issue that we will see litigation under COVID-19 claims based on whether or not a contamination or a concern of a contamination at an office space constitute physical damage at that office space. So in other words, you have someone who may or may not have gotten sick in the office, and as a result, you have to operations so that no one can then access the office. Is that physical damage? Is it physical loss? The answer I would tell you is that nationally, case law would suggest it is not, but no one has litigated a COVID-19 case on that issue. And I will also tell you that scores of people will. So that will be answered at some point in the next couple of years at the appellate division. There's no doubt in my mind. Has there been a suspension of operations? The typical language in a ISO form is it requires a total suspension of operations, a complete cessation. That's what the courts say about it, a complete cessation. A partial shutdown or a slowdown will not trigger coverage. People, I think, miss the point on this frequently because you think, well, I bought business interruption coverage. It must cover even if we're able to work, but we're not working as efficiently as we would have because we're all working from home, right? The concept makes sense, but that's not what the policy covers normally. So if you have classic language which requires a complete cessation of operations, it means exactly what you think, a complete cessation of operations. Operations generally defined, by the way, as your normal business activities. You have to be completely shut down to trigger coverage. The newer forms, so if your policy is on forms that were written in the last 5 years or so, there's a fair chance that total suspension was reduced to a partial suspension or slowdown. So what has happened is insurance companies have relaxed the total suspension language in order probably to broaden the coverage to their insureds. So again, it depends on what kind of policy you have, but pay attention to this because if you've got total suspension, it's a higher hurdle, obviously, than slowdown or partial shutdown. And some case law.
You had one question come in. If physical damage is required, then a government fee at closing non-essential businesses would not constitute covered loss. Is that right?
I think that's probably right, that a government, that an order saying shelter in place, or as we have here, a mandatory stay-at-home order, is not property damage per se. You will see challenges that it is. Why? Because you've got a policy and you want to trigger coverage, and it's a fair question to ask if a business, if a government's order prohibiting you from accessing your property is a physical loss of use. Historically, it hasn't been. It's tied to the case law from around the country ties it to there has to be some sort of actual impact on the physical structure. But that argument will come, and that's another thing that I guarantee you we will see a decision on at some point. I would not want to venture a guess as to how it would come out. That's an argument we'll see. It's a very good question. So back to suspension of operations issues again. For lawyers on the phone, I'm sorry to break this to you. If you have total suspension language, complete cessation language we just talked about, the Bucksbaum case out of California from 2002 is not what you're going to want to hear. So basically what happened in Bucksbaum is they had a covered cause of loss. They had a broken pipe and water damage, if I remember correctly. And they made a claim for business interruption. Why? Well, we couldn't go to the office and we lost an opportunity to work as efficiently as we normally would from our office. Does this sound familiar? Unfortunately, lawyers being lawyers will all find a way to work. And so you're always going to take client calls. You're always going to be thinking about something. You'll always be recording billable time. And where they were doing that in this case, they were recording billable time. They were working on files. They were talking to clients. They were going to court. Even though they couldn't go to their office, and even though they had an impact, no doubt, as to what they would have otherwise billed, it wasn't a complete cessation of operations. And as a result, they didn't have any right to coverage. So they had a covered cause of loss at the building. They had property damage, which fell within the scope of the coverage, but they never shut down completely. And as a result, they didn't have business interruption. So what you're seeing is again, what I'm trying to point out is these policies are very narrowly defined in scope. So no coverage for BI where there's damage to the hotel's kitchen and you have a lower occupancy rate. This is a Ramada case from, we can see this goes back to 1988. What happened here is the kitchen burned down, and as a result, people stayed somewhere else. Why? Because you want to have an on-site kitchen. And so they had a drop in occupancy rates, which no one argued had occurred. Problem is, they still were renting some rooms. And if you're renting some rooms, just not as many rooms, you've not completely stopped operations. So as a result, no coverage. Word on this point though, you'll note that you've got two different issues here. The kitchen itself wasn't operational. No doubt about that. And you had specific loss. It was a fire loss of the kitchen. No doubt about that. So while the hotel couldn't recover under its policy for its loss of room rentals, what it could recover for was the loss of food and drink that would have otherwise been sold from the kitchen. Why? Because the kitchen was completely and totally shut down. Just a few more of these. I'm gonna roll through them relatively quickly, but you'll see over the years. And by the way, if anybody is interested in this PowerPoint, feel free to email me afterwards. I'm easy to find. I'll be happy to send it to you. But there's a number of cases here, as you can see, which deal with this issue, where you've got physical damage, but you don't have an actual cessation of operations. Madison Maidens is another one. This is not a World Trade Center case, but it's out of that same sort of case law. Again, what happened here is they had a flood at the office. The flood was covered, but only 2 of their overall staff were able to continue some basic normal operations. The Southern District of New York in 2006 says that is not a complete cessation of operations, and as a result, coverage is up. Broad Street LLC, here you've got an apartment building which was very close to the 1 and 2 World Trade Center, was damaged as a result of debris and dust, and they had to make changes to the filters in the building. They had to do some repairs to the HVAC units in the building, and as a result, they were shut down for a couple weeks. The problem is people didn't return back to the property for several months after 9/11. So the argument was, well, we had physical damage and we had a cessation of operations. The first department agreed, you did, right until the point you were able to return to operations. And when you didn't return to operation, even though you were able to open, and you were open for people to come and move back into their apartments, the fact that they didn't is not enough to trigger coverage. You had to actually be closed and unable to offer your services to trigger business interruption coverage. So think about how Broad Street would play with a coronavirus, a COVID-19 type of loss. That Broad Street case is very helpful and I think instructive as to what we're looking at. The next point, on a business interruption claim. The period of restoration and or indemnity shall not exceed the length of time which would be required with the exercise of due diligence and dispatch to repair, rebuild, or replace such property that has been destroyed or damaged. Again, destroyed, damaged, pointing back to something more than just an inability to access, some sort of physical, tangible incident, trauma. Period of restoration, basically, depending on your policy, it will trigger immediately, it will trigger within 72 hours, but it tells you when the business interruption coverage actually kicks in, and it also tells you when it stops. The period of restoration stops when, theoretically, you could have made repairs and reopened for business. So you can't drag your feet on fixing your property to extend the amount of business interruption. It's not based on when you actually reopen, it's based on when you could have reasonably reopened as a result of a covered loss. The period of restoration is to enable insureds to continue to receive lost profits at the insured location until the insured location can be rebuilt or refurbished. The insured cannot be forced to move to a non-suitable location without being permitted time to make necessary alterations and updates to the new location. This is Dwayne Reed that was in the World Trade Center in an argument over whether or not they could open up another drugstore somewhere unrelated to where they were, a geographic issue. Period of restoration should be tied to remedies within the control of the insured. For example, suitable alternatives and or making sure that you commission repairs, getting people in to do the work. So how does period of restoration tie back to COVID-19 in those types of cases that we expect to come forward? The Broad Street LLC case, again, I think is going to be indicative of what you're looking at. In that case, they did make repairs to things that were arguably physically damaged. HVAC units, filters, things of those sort. But after the repairs were made, the period of restoration ended. So even if you can establish, and people may be able to establish this, there's going to be an argument over that a contamination or a possible contamination as a result of someone shedding COVID-19, I think that's the technical term, shedding the virus, in the office, that is a physical loss. Even if you can establish that, you're only entitled to coverage for the period that it would take to have actually repaired or replaced or mitigated your office space. My understanding was and is that if you suspected contamination, that essentially the treatment was to fog your office space, and that would kill the virus in theory, and restore it to your office to safe use. So how long does it take to fog an office? A couple days, right? You're not looking at really extending this beyond. So the point here is there's going to be a lot of arguments to try to put a COVID-19 claim into the business interruption coverage, and it really is a square peg in a round hole. It's what you're dealing with is traditional property coverage and trying to apply it to a non-property event. And it's not fitting well, as you can see, and it's going to cause a lot of problems for policyholders who are going to try to make these arguments. Because the case law, as you can also see, is pretty well defined that it's tied back to that original property policy. Where the insured chooses not to relocate after its store is destroyed, the period of restoration is governed by calculating how long it would take to resume operations at another location. Again, it's a theoretical thought. It's not the actual return. It's when could you have returned? When could you have made repairs? When could you have cleaned and or disinfected the office? Extra expense. Extra expense is a type of coverage extension that it's in a business interruption policy. It's found again in most ISO insurance service offices. And for those of you, by the way, I've used that term a couple times. For those of you who don't know what ISO is, the insurance service offices prepares a number of policy forms which many carriers will rely on. Basically, it's a repository of forms, and the insurance companies will pick which forms they want to build a policy for an insured. So when we refer to a typical ISO policy, what we're saying is this is really the standard. Insurance companies are free to change those policies as they see fit, and they apply to the Department of Financial Services, which was formerly the Insurance Department, to have their respective endorsements approved by the state administrative agency that's responsible for insurance, the Department of Financial Services. So the typical ISO policy defines extra expense as this. It's a necessary expense you incurred during the period of restoration that you would not have incurred if there had been no direct physical loss or damage to property caused by or resulting from a covered cause of loss. Tying it again back to that first part of the policy. So this is not income that you lost, but this is additional expense that you caused to help mitigate your loss of income, right? If you incur cost in moving facilities, you incur cost in upgrading new facilities so that you can maintain connectivity with clients, maintain connectivity with customers, that's a possible extra expense claim. However, again, you got to have property damage. Extra expense applies again, it's incurred in relocating a business operations, people and equipment, updating alternative locations, repairing, replacing lost information, and any other expenses aimed at, really, it's a mitigation question, right? This is if you have extra expense, which wouldn't otherwise be business income, but it's you incur that expense to mitigate your loss of income, that's covered under a policy.
Steve,
It does not help. Oh, I'm sorry.
Nope. You had another question come in. If a business has 2 or 3 locations, one of which has sustained a physical loss by fire, the other locations remaining in the business, is that a covered loss?
A great question. And there's not a lot of authority on that issue. And I've looked. I think the answer to that question is, if generally what happens is in a property policy, we cover a specific location or area. So you may have one policy, but it'll cover 3 different buildings. If you have a building that you conduct operations out of, and that building is damaged by fire, then the loss of use arising out of that damaged building would generally trigger business interruption coverage. It's not a global question, it's tied location specific. So your losses, however, would and could be offset by using other operations to continue, or other locations to continue your operations. So if you shift, if it's 3 manufacturing facilities, for instance, and you shifted extra work to these other 2 locations, that would offset any potential losses that you would have had out of the damaged location. There's a couple. There's a case from 1980 in the Court of Appeals called Howard Stores, which talks about if you shift things around and don't actually sustain, quote, remember, an actual loss, you don't get coverage. It's a very, very good question. Hopefully that answered it. Extra expense does not apply to gratuitous payments made by the insured to a third party to ensure goodwill. You can see this, right? We'll give you this one for free. We know we were down for a couple weeks, and we recognize that we caused an issue with you. So we're going to give you a discount or a break or whatever. That's not an extra expense. It's got to be tied towards mitigating your loss, not creating new loss. Again, loss where you haven't had permanent suspension of business or operations. No case in New York that said this, but this is a Massachusetts case that we found that said it. It makes sense, because if the extra expense really grows out of your business interruption coverage, and the business interruption coverage requires a permanent suspension or complete cessation, as the courts would describe it, your extra expense has to arise out of that as well. So it's a little confusing, because one would think, well, if I spent extra money so I didn't have a complete interruption, then why wouldn't that be covered as an extra expense? The answer is that it's not. The logical argument, and that's the argument that was made in the case referenced below. Is there civil authority coverage? More good stuff. Civil authority coverage is the yin to the yang of business interruption. It's found in the same policy form. And it's important, it's particularly relevant in the COVID-19 area. Why? Because the problem with your business interruption policies we've gone through ad nauseum in this presentation is you got to have physical loss or damage to the property at your location, which is covered by your policy. Civil authority says it's the exact opposite. Civil authority grant, as on the screen, action of civil authority that prohibits access to the described premises, and sounds pretty good if you're a policyholder, due to the direct physical loss or damage to property other than at the described premises caused by or resulting from a covered cause of loss. We're back to the same problem again. You still got to establish physical loss or damage to property. It just can't be your property. It has to be somebody else's property. And that loss has to be covered, right? So think of this in the construct of a flood, right? Property policies generally don't cover flood. The National Flood Insurance Program covers flood. So if you have loss because the power station down the road got flooded out, it may not be a great example, but you have the bridge got washed out down the road. There's physical damage, yes. Would it be covered cause of loss? No. Why? Because the bridge got washed out. So it was caused by flood, and the flood's excluded. So you have to have direct physical loss away from the described premises, and it can't be otherwise excluded by the exclusions in the policy. The big issue the big issue with COVID cases, and the problem that we're going to have in establishing a civil authority case, in addition to the direct physical harm, which is a big hurdle to get over, is the third dash on this slide. The action must prohibit access to your location. There has to be a causal link between the action taken by the government and your location. So, in New York, we may be able to, an argument can be made that if it's a shelter and home place and you will be prosecuted if you go to your office, that is a directly prohibiting access to your office. But I will tell you categorically, the drawdown of 25%, 50% to offices, the social distancing mandates that came out in early March, those do not prohibit access to any insured location. They were just guidelines that were handed out. So that's not going to be, in my opinion, will not be enough to establish the connectivity that you need between the causal connection between the actual order of the government and the inability to access the premises. Philadelphia parking authority is a great example of this. Here's how the concept works. Well, no one could fly, and the FAA told everyone you couldn't get on a plane, couldn't fly. So civil authority prohibited access to our property. Southern District says no. The FAA prohibited access to planes taking off. It prohibited planes from taking off. It didn't prohibit anybody from parking in your parking garage. So as a result, while you have a loss, you don't have a loss that was caused as a result of a government order which prohibited people from actually going to the parking garage. Folks could have gone, parked in your parking lot, walked around the tarmac, I suppose, gotten back in their car and driven away. So the order isn't tied to the outcome, and it has to be for civil authority, unless your policy says something different. Exclusions. Are there exclusions which apply? Here's a list of them that you'll see. The one thing that you're going to see a lot about is the virus exclusion. Let me give you just a quick minute on a virus exclusion. Back in 2008, 2009, after SARS, insurance companies petitioned state insurance departments and asked for the authority to create a virus exclusion which said, we don't want to cover losses arising out of viruses. The insurance departments invariably approve those, and they're on policies. So in addition to having a hard time proving physical loss, even if you say the virus is in fact causing physical loss and physical damage, if you have a virus exclusion, insurance companies are saying, well, listen, we wrote an exclusion that's directly on point that says, even if virus causes property damage or loss of you or physical loss to your property, it's excluded, and here's the endorsement. Huge fight coming on that one as well. I guarantee you we're going to see case law on this one. So stay tuned on that. Celeste, you want to hop in?
Can I interrupt you for a second? Do you do the CLE code? The CLE code for this seminar is CS20. Again, the CLE code for this seminar is CS20. Thanks, Steve.
Great. So I have about 50 minutes. I think I have about, I don't know, 3 or 4, maybe 5 minutes left, which is good because I got about 5 minutes left of materials. Valuation of damages. If you actually get over these hurdles, and again, by the way, this might sound bleak. I'm not trying to say that it's impossible. What I would tell you is, if I had my crystal ball, there will be some claims that get through. There are going to be some law which creates coverage or which affirms coverage for business interruption. So what I'm trying to give you is a sense of what the playing field looks like and where the battles are coming. So I don't mean to sound overly bleak. If I do, the case law on this is not good for policyholders. So it hasn't been for years, as you can see. And hopefully this will give you some historic background as to why we think that. The big question here, the big issue here in valuation of damages is, if you remember back to the beginning, first slide, the business interruption policy covers actual loss. It doesn't cover losses which are offset by other factors. If a business applied for the Paycheck Protection Plan, CARES Act, other state and local government funding, which could be coming, and you get that, is that an offset? In other words, can you get insurance for a business interruption loss and also get paycheck protection funding for the same period of loss? And fundamentally, I would say probably not, because the policy is tied to actual loss. And if you got money from somewhere else, it's not a loss. But if you have to pay that money back, do you now have a loss? Maybe you do. I wish I had a better answer for you, but until we get actual regulations from the Small Business Administration which cover how this Paycheck Protection Plan and other federal programs are going to be administered, and particularly with respect to the forgiveness part of those loans, no one, I don't think, can answer the question as to what we're looking at. This is not all property. And it's not all business interruption as well. That's the focus of this presentation, but briefly a word on this. Keep this in mind. We're over 60,000. This was done last week. We were at 63,000. I think we're over 70,000 deaths tragically in the country to date, and more doubtless to come. There's no doubt that we're going to see wrongful death claims, bodily injury claims, malpractice claims against not only the medical field, but insurance agents and brokers who wrote policies for insureds who don't have coverage for business interruption. They're going to get sued. You're going to see ADA claims. You're going to see a number of liability claims arising out of this, which will have very interesting tort implications as well as casualty coverage implications. So a word as to what we can expect. There are communicable disease exclusions on your homeowner's policy. So think about this as a potential case down the road. Someone knows they have COVID-19 and they refuse. We've seen this, thankfully it's sporadic, but we've seen it, where people just refuse to self-isolate. And they know that they're infectious. And they go out and infect people, and that person then gets very, very sick, or maybe tragically passes away. Is there liability there? There may be. I don't know. Is there coverage under your homeowner's policy for that? Again, there may be, or there may be a communicable disease exclusion. The virus exclusion on commercial property policies is going to be in play as well for things to think about. This is going to be a huge driver of litigation, I think, nationally and also in New York, unless we have some sort of major funding act that comes out of the federal government. To that end, and I think I'm over my time, but I'm going to take it for 2 minutes, if you'll be so inclined to indulge me. To that end, there are state proposals that are primarily dealing right now with business interruption. You can see them around the country. Pennsylvania has a very, very, very sweepingly large bill that's in place right now that's going to create essentially coverage if you're a business which falls into a specific size. They're going to create coverage whether you even had a policy, whether you even bought business interruption. If you had insurance, it covers business interruption and it covers it implicitly. That raises some very, very serious constitutional questions for those of us who defend insurance companies. But legislatures are thinking about this, including New York. The latest
Steve,
bill, yep.
You did have a question come up. How do you think the inclusion of communicable disease language and virus exclusions language will be read together?
Well, I think you typically wouldn't see both of them on the same policy, right? The communicable disease exclusion is usually found in a homeowner's policy. The virus exclusion is more of a commercial policy endorsement. They mean basically the same thing, which means if you cause property damage or bodily injury as a result of a disease, we're not covering you. That's a communicable disease exclusion. And if you have a loss or sued because you caused a loss on a commercial basis, the virus exclusion kicks in. What we're seeing nationally, and this is an interesting argument. I think it has some fundamental flaws, but we're seeing it nationally. We've seen it a couple of lawsuits around the country. Is the argument that if you don't have a virus exclusion, then therefore you must have implicitly understood that you were going to cover claims arising out of a virus. Because you could have excluded it and you didn't, therefore it must be covered. That's putting the cart a bit ahead of the horse, because the question is it covered in the first place? The lack of an exclusion doesn't create coverage. You have to create coverage first, and then the exclusion applies to take it away. But we're seeing people probe those issues because the virus exclusion is front and center on these commercial cases moving forward. So an argument to be certainly at least aware of. The New York law, which is currently in draft form, you can see it's A10226B, which means it's on its at least second amendment at this point. It retroactively construes business interruption coverage to include coverage for a period declared COVID-19 state of emergency. It applies to ensure to fewer than 250 employees. And basically what the sponsor of the bill is suggesting is, look, we have to administer help to businesses somehow. Here's how we're going to do it. We're going to do it on the back of the insurance company. Insurance company, you are going to be mandated essentially to cover it. And you'll notice at the end, they nullify any virus or bacteria exclusion. So we're getting rid of that as well, even though it was approved, I remind you, by DFS 10 years ago as an appropriate exclusion to add to the policy. There was a very good quote from a lawmaker who's sponsoring this bill who said yesterday in the paper downstate, well, yeah, but DFS couldn't have possibly realized that there would be a pandemic coming 10 years from now. I would submit to you that they absolutely knew that was the basis for the virus exclusion, because that's why carriers applied to have it approved by DFS in the first place. Nevertheless, government sees it differently now than they did in 2009. There's a push to try to get rid of and essentially outlaw the virus exclusion, which the New York State government, in fact, approved in 2009. So we'll see how that goes. But that's part of this bill. Basically what they want to do, the plan is we'll have insurance companies pay the loss, which would be catastrophic if you can imagine how many business interruption policies are out there, how many businesses are closed as a result of COVID-19. We'll have them pay the loss, and they can apply back to DFS, and we'll reimburse them. ... And then we'll charge it back to the insurance companies based on net written premium, which ultimately in that situation either bankrupts the carrier or they pass it on to the policyholders. So it is a circular argument, but this is what they look like nationally. Federal language, there are proposals as of May 1 There's the business interruption insurance coverage, which retroactively requires carriers who sold BI coverage to provide business closures resulting from viral pandemics and forced government closures. That's along the lines of what we're seeing in New York, New Jersey, Pennsylvania, and other places. And then the Never Again Small Business Protection Act, which ensures that carriers can't avoid paying this in the future. They're trying to legislatively create a federal mandate for BI coverage, business interruption coverage, for future national emergencies. It's a very interesting issue. In the 30s, there was an act called McCarran-Ferguson that was passed, which basically said issues of insurance go to the state. They're not administered at a federal level. So how this interplays with McCarran-Ferguson and the tradition that states get to run their own insurance is going to be an interesting question if, in fact, these things get passed. You'll see their House resolutions. They have not been passed, and who knows if they'll be signed by the administration. Although you'll note that the president at one point did say he thought business interruption should be covered by insurance policies. So don't know where that's going, but he has said it. In any event, it gives you an idea what we're seeing. There are cases going. I think the first case that I'm certainly aware of was filed last week in New York State. It's in the Southern District of New York, challenging denials. We're going to see this litigation. When courts open up in New York, state courts open up, I would expect there's going to be a flood of cases that come in because New York is hit hard by this, as we all know, and businesses are hit hard by this. And, we've been on hold for filing lawsuits. So one must assume that they're piling up and they'll be coming shortly. So I hope this was helpful. As a final plug and maybe somewhat of an educational resource for you if you're interested in this. Not only do we have a newsletter that we put out every other week, which goes through cases that come out and provides basically a running digest of cases, but two of my colleagues have done two repositories based on COVID-19. One of them is we're grabbing every case that we're aware of and writing a synopsis of what the allegations in the complaint are. So if you're wondering who's gotten sued where and what the allegations are, it's a pretty good resource. Lee Siegel, my partner in Connecticut, is working on this, and it's really remarkable. It's worth checking out on our website, and if you have any interest. And if you have any other interest in the legislative proposals, Ryan Maxwell, my office, has done an awesome job of finding these legislative proposals, cataloging them for ease of reference. So it doesn't cost you anything. You don't even have to tell us you're doing it. I just want to let you know they're out there. They're great resources if you have any interest in what's going on around the country on those two particular issues, lawsuits filed and legislative proposals and where they are. But with that, thank you very much. I don't think we lost too many people, dropped off, so I must have been that point. Thank you.
Thank you, Steve. I think there are no more questions. So I'd like to say it was a great presentation. Thank you for all your time and effort putting this program on. To everyone, I would like to remind you to email your CLE form and evaluation back to me. Again, my email is cwalsh@eriebar.org. Thanks again to everyone for joining us. We appreciate your support of the Bar Association of Erie County. And with that, I'd like to hand it back over to Megan for a couple more things.
Thanks everybody for joining. Just a quick reminder, and thank you, Steve, for presenting. Quick reminder, we do have, the Law Alumni Association has more free CLEs coming up in the next couple months that are available to NEUB law grads, and some of them we're co-sponsoring. And you can also see those on our website. And if you're interested, joining the Law Alumni Association, that is also on the website, and we provide these and other services throughout the year. But thanks, Steve. Appreciate it.
My pleasure. Thank you.